moving forward in chapter 1, we're going to next start talking about things such as the Unemployment Tax Acts, move on to some of the other fair employment laws. Much of this information, as you'll notice as we move through, we actually cover in greater depth how it works in later chapters. At this juncture, what we are is we're familiarizing you with the reasons why. From a payroll accounting advantage, we have to do certain things that we do. As an employee, you have been subject to all of these laws at some point, whether they were something that you were aware of or not. So starting with the Unemployment Tax Acts, there are two of them. There's the Federal Unemployment Tax Act and the State Unemployment Tax Act. Underneath the Federal Unemployment Tax Act, employers are levied a tax on the first $7,000 that they pay each employee every year. The taxes are used to pay state and federal administrative expenses only. They actually do not go towards the unemployment benefits that are paid to the individuals that are filing for unemployment. The State Unemployment Tax Act, though, is where the benefits are paid to individuals who are unemployed. There is mandatory unemployment insurance. Every state is different. They have different rates. The Social Security Act outlined the standards that each state's unemployment compensation laws have to follow. It is very important to be aware when you do business in more than one state, so you have employees in more than one state, what the State Unemployment Tax Act and the laws are for each of the states in which they operate. Moving into the fair employment laws. These are all the different types of laws that impact employers and employees and the relationship between them. First and foremost is the Equal Employment Opportunity Act, which is Title VII of the Civil Rights Act of 1964. And this provided initially for several fair employment practices. Beyond this particular act, we have expanded, and we'll talk about those more a little later. But during 1964, the Civil Rights Act and Title VII brought about a prohibition in the discrimination in the hiring, firing, promoting, or compensating based on color, race, religion, national origin, or gender. This applies to all employers who engage in industry affecting commerce and who employ 15 or more workers in each of 20 or more weeks in a year. Building upon that, the Civil Rights Act of 1991 resulted in some compensatory and punitive damages in cases where discrimination was proved to be intentional. Here we have one of those links that you really would probably behoove you to look at, and that is www.eeoc.gov. Here there's additional information and some more background into how all of this came about. The EEOC prohibits unions from excluding or segregating members on these bases, and employment agencies also are affected. Title VII, though, does not protect employees from arbitrary treatment or dismissal, as long as the employer can apply policies in a non-discriminatory manner. Title VII has not been violated. a lot of people will like to say, I was fired for reason X. In an at-will state, there is no necessity for an employer to terminate employment. That may come for any reason or no reason stated at all. The Age Discrimination in Employment Act came about in 1967. You'll notice that it was just behind the Civil Rights Act. And it states that employers can't use age to discriminate in hiring, firing, or employing or promoting. It applies to employers engaged in interstate commerce with 20 or more employees. And it provides protection to workers who are over the age of 40, with a few key exceptions. It's important to understand that with all of these acts, it comes down to policy and documentation in order for the employer to prove that they have accurate policies and procedures in place. The Age Discrimination in Employment Act actually did directly place onus on the employers to keep accurate personnel and payroll records. Continuing to build on fair employment was the Americans with Disabilities Act. This came about in 1990, and it prohibits employers with 15 or more employees, employment agencies, labor organizations, joint labor management committees, from discriminating against individuals who are qualified but have a disability because of their disability. Reasonable accommodations have to be provided, and this is a very vague term. Whenever we hear the word reasonable, there leaves a lot of room for interpretation. What is or is not reasonable can vastly differ from one organization to another. Therefore, when there is contention and a belief that someone has violated the Americans with Disabilities Act, it comes down to the reasonable accommodation and court interpretation, typically, because there is not a specific guide that says XYZ has to be done. Just take a moment and ponder the different assets, resources, and just plain size of a sole proprietorship that is, for example, in a storefront versus, say, a large corporation like Walmart. Qualified persons are defined as being a person that can perform the essential functions of the job with or without reasonable accommodation. Next, we have the Federal Personal Responsibility and Work Opportunity Reconciliation Act of 1996, a relatively new act that requires employers to report information on all new hires within 20 days to the state agency. The information that must be reported includes your name, address, and social security number. Records are then coordinated with the Federal Office of Child Support Enforcement. Failure to report can result in a $25 per hire fine levied for that failure. There are now some states that require the same in regards to your independent contractor. This was an effort to help enforce child support obligations and ensure that child support orders are being carried out. Next one that we'll speak about is the Immigration Reform and Control Act of 1986, IRCA. This is a law that bars the hiring and retaining of aliens that are unauthorized to work in the U.S. It is accomplished by the employee completing the Form I-9 If you've ever had a job, you have completed the I-9, which is the Employment Eligibility Verification Form, and that has to be done within 3 business days of employment. With this particular form, U.S. Citizenship and Immigration Services can audit and levy civil penalties, and criminal penalties can apply if there's a pattern of discriminatory practices that may be found. The E-Verify program is a government-run system that allows employers to check the employment eligibility of new hires by cross-matching the information from the I-9 with the Social Security Administration. This is currently a voluntary program, although there are some federal contracts that different companies engage with the federal government on that actually require an E-Verify clause. The Family Medical Leave Act, FMLA, of 1993 is often a misunderstood act. So this is an act that actually covers companies that have 50 or more employees within a 75-mile radius. So it actually does not apply to every single company in the United States. Employees are guaranteed 12 weeks of unpaid leave for very specific purposes: the birth, adoption, or critical care for a child, spouse, or a parent. You can use the leave all at once or at separate times within 12 months of what is deemed a qualifying event. The employer must continue health care coverage during that period. And there is a right to return. Now, that is not necessarily to the exact same job, but it is either to the same job or a relatively comparable position. FMLA expanded to include up to 12 weeks when a family member is on active duty, or 26 weeks for line of duty injuries or illnesses. Now, employers can exempt some employees in specific situations. And keep in mind that there are some states that have some very favorable employment laws that actually have a requirement for paid family leave plans, but the FMLA Act itself does not call for the employee to have to be paid. Employers' exemptions can apply to the highest paid 10% of their workforce. This is quite often, and typically you're looking at higher level management, integral operational executives, or those who have not worked at least 1 year and at least 1,250 hours in the previous 12 months for the company. The Uniform Services Employment and Reemployment Rights Act of 1994 gave military personnel the right to take leaves of absences from their civilian jobs. They have the right to return to their prior jobs with their seniority intact, and that must be granted within 2 weeks of the job request. Health benefits would be started immediately without a waiting period. But if you are dishonorably discharged, this does not apply to you. IRCA, or the Employee Retirement Income Security Act of 1974, was legislation that safeguarded the pension funds and insured workers were covered by private pension plans, received their benefits in accordance with their credited years of service. It states that trustees must monitor pension plans and that there must be vesting of 100% in 3 or 6 years graduated. That means it goes a certain percentage at steps. So, for example, if you're there 2 years, you're 20% vested in the plan, 3 years, 40%, 4 years, 60%, so on and so forth. It also brought about the Pension Benefit Guarantee Corporation, which is a federal agency which guarantees benefits to the employee if for some reasons a plan fails and can't pay benefits. ERISA does require some stringent record keeping, And employees are eligible after reaching the age 21 or completing 1 year of service, whichever is later. Annually, employers must file Form 5500 in accordance with IRCA. Now remember, these are pension and welfare plans that are maintained by employers or employee organizations representing the employees engaged in commerce. This is not in regards to 401ks. What has been a relatively controversial act and effectively termed Obamacare, the Affordable Care Act of 2010, had two pieces of legislation within it. There was the Healthcare and Education Reconciliation Act and the Patient Protection and Affordable Care Act. Underneath the Patient Protection and Affordable Care Act, it was designed to expand healthcare coverage while increasing benefits and lowering costs. Coverage for individuals and dependents is required for almost all citizens. And it also created state-based health insurance exchanges. When this particular book went to press, there were some expected changes to ACA. We're going to continue to probably see ACA evolve a little bit as we go forward because many of the goals of ACA do not seem to have borne fruit. The ACA Act of 2010 required that the insurance provided by employers had to meet some specific coverage tests. There is the value test and the affordability test. It applies to large employers with 50 plus full-time employees and said that they had to provide group health coverage if they fell within that. We're going to just kind of touch base on some state laws. There's not a lot of them because every state can have different laws when it comes to their employment. Remember, if there is an applicable state law and a federal law, whichever one of the two is most advantageous to the employee, that is the amounts that or the benefits that the employee can expect to receive. So the first thing to talk about is workers' compensation. So this is when a worker or their dependent may experience a loss as a result of a work-related injury, illness, or a death. Most states require employers to pay the employee's premiums. There's workers' compensation insurance, and there are a variety of companies that actually cover this. Pinnacle is one of the biggest ones in the state of Colorado. If the state approves, an employer can self-insure. However, most cases, the employer takes out a third-party policy, such as with a Pinnacle or someone along those lines. There is different premiums that apply to employees that fall upon different job classes. So it falls into the same concept of risk and reward with insurance. An employee who is out in the field working with tools is more likely to be injured than an employee who sits at a desk all day. Therefore, the employee who is out in the field, there will be a higher premium associated with them versus the employee who's sitting at the reception desk. Benefits from workers' compensation insurance are used typically to cover the medical bills if an employee is injured or acquires an illness as a result of work. And they also have some percentage of wages that will be provided to the employee for the periods of time in which they cannot work as a result of that injury or illness. With death, it gets a little bit more extreme, and that goes a little bit beyond this overview. Some of the things you can find with workers' compensation is that as a organization, if you have a lot of injuries, all of your premiums will increase. And then there is a difference in how different type of injuries will impact your premium. Somebody gets something in their eye and they have to go to the optometrist and have their eye flushed, get some eye drops, make sure everything's all fine and good. That's not going to have as much of an impact on a premium as would, say, for example, an employee that were to receive something like a TBI or a traumatic brain injury. After a certain period of time, typically certain injuries will fall off your experience level, so your premiums can go down over time if you continue to have a safe workforce. There are some states that have disability benefit laws. There are 5, including Puerto Rico, that have established some laws requiring that the employers provide actual disability benefits to their employees. This applies regardless of how the disability, illness, or the disease have arisen. So, for example, in California, Hawaii, New Jersey, New York, Rhode Island, and Puerto Rico, if you are on vacation and you end up falling and breaking your leg and you can't work for 3 months because it's a compound fracture and requires a lot of other things, the state disability benefit law says that you would receive those benefits associated with that particular state law. You would not necessarily have to have broken your leg at work. That's the difference between workman's compensation and state disability benefits. Next, we're going to talk a little bit about human resources and the payroll accounting systems. However, since we are at a nice break when it comes to laws and the different things that impact those, we will talk about human resource and payroll accounting systems in the next couple of lectures and not this specific one.